The most dangerous and persistent harassers aren't always anonymous strangers on the internet. Frequently, they are members of your own family. Take the case of a man we'll call Arnold. For 2 years, Arnold and his relatives lived under a relentless campaign of harassment orchestrated by his uncle, John, who was operating from Germany. John systematically targeted the family's livelihoods. He fed fabricated stories to a school where Arnold's wife served as a trustee, sent fake legal threats to Arnold's father, and bombarded in-laws with emails threatening the reputations of elderly relatives. The stress peaked when Arnold's wife became pregnant. Fearing John would target her directly if he knew, the family was forced to keep the pregnancy a complete secret. Because much of the abuse was concentrated on Facebook, almost the entire extended family deleted their social media profiles and went into hiding. The family lived in a state of constant alert, needing a way to stop the conduct before the abuse could escalate further. Arnold followed the standard protocol. He reported his uncle's actions to the police, but the police refused to act. They incorrectly dismissed the harassment as a civil matter because it involved family members, rather than treating it as a criminal offense. They also claimed John was beyond UK jurisdiction because he resided in Germany, a claim that was legally inaccurate. While an appeal process exists to challenge a police refusal to investigate, those bureaucratic battles can take months that Arnold's family simply did not have. When authorities abdicate their duty, victims are left in a vacuum, defenseless against an escalating, borderless threat. Cohen-Davis solicitors stepped in to move the family from defense to offense. The primary legal weapon in these cases is the Protection from Harassment Act 1997. This legislation allows victims to bypass the police entirely and directly seek aggressive civil injunctions to stop the harasser. Filing for a cross-border injunction immediately is an expensive process. To save the client costs, the firm took a different strategic path first. They silently built a trial-ready case up front, compiling comprehensive witness statements and digital evidence of the Facebook harassment. This level of preparation turns a potential trial into a foregone conclusion, allowing the firm to demand a resolution before a judge ever sees the case. John's campaign immediately hit a brick wall when a massive 17-page legal warning finally arrived at his doorstep in Germany. Unlike criminal courts requiring proof beyond reasonable doubt, civil courts use the balance of probabilities, just 51%. Our evidence easily cleared that threshold, guaranteeing his loss. Furthermore, forcing a formal injunction would make John liable for all expensive international legal costs. He was offered a way out: stop all contact immediately, cover Arnold's existing legal fees, and pay damages for past conduct. By making the potential financial cost of fighting the case undeniably ruinous, the legal team successfully called the harasser's bluff. Faced with a trial-ready case and the prospect of paying thousands in legal fees, John complied with all demands immediately. The harassment ended expeditiously, without the family ever having to fund a multi-year international court battle. Arnold, his pregnant wife, and the extended family finally regained their security, using civil law to succeed exactly where the police failed. An abusive family member is not untouchable, regardless of international borders or uncooperative police departments. Family harassment is a serious legal offense, and civil litigation provides the levers necessary to force it to a stop. If you are facing relentless harassment, do not wait on the authorities. Contact Cohen-Davis solicitors today to take control of your situation and protect your family.